Today breeds a very important discussion on one's right to make an application before the court for prescriptive title. Now, you would recognize that in Guyana there is a particular legislation, and the name of that legislation is Title to Land Prescription and Limitation Act, Chapter 6002. Now, that piece of legislation in Guyana affords one the opportunity to make an application for prescription. In this case, you're asking the court to make a declaration of title. Now, I want to go through maybe three important sections of that piece of legislation, which I believe is important for you to know. Now, first of all, you may want to pay attention to Section 3. Section 3 of that act will tell you how long you need to live on a piece of land um, before an application can be made. The act is very clear. You have to be there for 12 years and more. If you fall below that 12 years, then you would not have, of course, satisfied the requirement of the legislation to make an application for prescriptive title. Now, you must be very much aware, and I believe it's important for you to understand that fitting yourself comfortably under the act to make the application is one thing. But I believe whenever one talks about making an application for prescription, one needs to be very much comfortable with what the common law position is. So, in this discussion, I will make reference to what the common law position is and what the legislation say. Now, of course, you would recognize that once you have a legislation in place, then your legislation, of course, is what will guide the court. And of course, any common law position will become secondary. But there are some terms used in the legislation. For example, one must be in possession. Now, you may have to go forward and ask yourself, how is the word possession defined? And of course, we have a number of cases in the common law which gives a very clear definition and a very clear explanation as to how one can be in possession. Now, the law is very clear. If you are in possession, you have to be in possession under a particular category. In this case, when you are applying for prescriptive title, you can call yourself a squatter, meaning that you do not have a legitimate right to be there. So that, let's say you have inherit the property, and this is a different branch of the law in which we call succession law. If you have inherited the property from your great grandmother or from your grandfather, or it passed down from generations, you will ask yourself, am I a squatter? Am I there without any legal authority? If you are there with some legal authority, meaning that you have inherited, someone has inherited the place, or you are a beneficial owner of that place, or you have a beneficial interest in the place, in that property, then you may not apply, or you cannot apply for prescriptive title, because the law is going to bar you. So think of this very clearly. In order for you to make an application comfortably under the law for prescriptive title, it means that you would have occupied the land or the property without any legal right, and you have done so for 12 years and more. Now, Section 4 of that Title to Land Prescription and Limitation Act, Chapter 6002, of course, gives the court the power to make a declaration of title if your application is successful. Now, I want to examine for a very short moment this whole issue of possession. Now, remember, I said that you need to be one who is occupying land without any legal right. So let's say you are a squatter. Now, you have to be, the law says, in order for you to be in possession, you have to have possession singly and exclusive, meaning that you have to be there without the permission, or you're there without any control of anyone else, and no one else has access or control to the property. So let's see, if four of you are squatting on a piece of land and you do not have exclusive right to the land, meaning you can't go and make any improvements to the land, you can't put up your fence, or you can't do any type of planting on the land, then you will not qualify under the law to say that you have been there singly, and you have exclusive right to the place. It means that you do not have exclusive possession. What does exclusive means? It means without the control or authority or infall or influence or interference of any other person. So that this is one of the qualifications of the issue of one having possession of a property in order to qualify you to come under the act. In a subsequent discussion, we are going to go further to interrogate and to examine this whole issue of exclusivity and one being there singly. Because you may ask a question, okay, well, I have four persons or five persons living on the land, but we are living there jointly. And I will tell you, of course, how the law treats with persons who are living jointly on the land. So I want to thank you for this, for listening for this presentation, and I hope to see you on a subsequent presentation. Audio Jungle.